Hi, my name is Mike Rutkowski, estate planning and elder law attorney here at the Rutkowski Law Firm. What are you doing in here?
Hey Dad, you're in my chair.
In your chair? I'm not giving up my chair.
Welcome to the Rutkowski Law Firm.
Welcome to Life Lessons with the Rutkowski Law Firm, where we break down the complex world of estate planning into simple, actionable steps. As an experienced estate planning attorney, Michael Rutkowski has helped countless families protect their assets, avoid costly mistakes, and create lasting legacies. Today, we'll be focused on what a will is, why it's important, but why it's also not enough. And here to help us today is Michael Rutkowski, estate planning, Medicaid, and elder law attorney. Michael, welcome.
Let me help. I know there's a lot of people out there creating their own wills, so let me give you a little guidance to start there, and then we'll talk about the differences, maybe wills and trusts, and what happens with a will. Because actually, just yesterday, I was going through one of the softwares online because I just wanted to see what the user experience was with one of these online software generating. And so let's just talk about some things you need to be aware of. First is that if you're married, one thing that I saw in the software that wasn't as obvious is that with wills, everyone needs their own will. So if you're a married couple, you each need your own will. And it might be something like you say, my spouse gets everything and then my kids. So don't skip the spouse, because I've seen that happen too often in online created. They didn't know that they had to first give everything to the spouse and then to the kids. They just put right to the kids. So know that in a married couple, you have to have your own wills, his and hers or whatever. And then you can say everything to my spouse and then to my kids. Sometimes that's referred to as a sweetheart will. The other thing you need to know is who's going to be the executor or personal representative. Every state, it's called something a little different. I mean, there's all these legal terms, but it's essentially who's going to manage your estate when you're gone. Is that going to be your spouse first, somewhere, or the kids after that? But that's the next important part, because knowing this, that a will still has to go through the probate process. Essentially, a will is just evidence to a judge as to what your wishes are. You have to appoint who's the one that's going to take this to court and make sure it all happens the way you wanted it to. We're in the probate court when it comes to creating a will versus a trust avoids all that. So know that when you're getting into it, but you each need your own will. You got to appoint something called a personal representative or executor. You get to pick if they're compensated for doing so, and that should all be done in the document. And then you get to say who gets what. The thing you need to know about wills is that the judge, like I mentioned before, it's just evidence of what your wishes were. The judge doesn't have to accept the will. Sometimes I'm in a probate contest right now where the will wasn't executed properly. So it's not going to be admitted as evidence of what that person wanted. So if there's a reason, which there's lots of reasons why a judge might not accept a will in full, in part, then it goes to what's called intestate succession. Essentially, every state has its rules as to what's going to happen to your stuff if you don't have a plan. So it's either, do you want your plan or the state's plan? To guarantee your plan, you should be looking at a trust. But in the event that that isn't something for you and you want to do a will is how you're going to submit what your wishes were.
Yep. So when you do a will, you need one for each person within if they're parents.
Yep.
And then you need to actually say who your stuff's going to in terms of to your spouse, either side, and then to the kids. And it still has to go in front of a judge. Let's just assume people want to still go down this route for a second because they're already on the path. They know that they want a will. What needs to go in? You mentioned a couple pieces, right? In terms of the beneficiary.
Yep.
When you say who gets your stuff, there's a lot of stuff.
Yeah, sure.
What are the key aspects of stuff should you consider going into your will?
So you're gonna, let's just see here. There's going to be 3 categories of stuff that you need to deal with, or at least how it's going to be all written out in the plan. You have to deal with tangible personal property. So this is like household furnishings, jewelry, cars, pets. Okay, so you need to make some provisions for tangible personal property. A lot of times a will or a trust will mention a separate document, which is like a line item sheet, a memorandum where you can then write what you want to happen. But otherwise, first thing you're going to deal with is tangible personal property. Then you're going to deal with real estate. So, okay, you have your house, your vacation properties, your timeshares, anything that if your name is on a deed anywhere, you need to make sure you're referencing what you want to happen to that. And then there's like your financial assets. There's your bank accounts and all that. So you got to kind of go through those things. You're going to also, where you're going to lay a lot of this out is in what's called the residuary beneficiary section. Essentially, after we give away your tangible personal property, everything that's left is called your residuary assets, and that's going to be handled in that section. So then you can say equally to my kids or whatever you want to do there, but that's going to handle the rest of it.
In terms of you have these pieces in terms of, like we said, the one for each person, the beneficiary, and then the different types of assets in terms of what you laid out. Now, why is this not good enough in court?
It all depends on what your goals are. If we meet with some families who are like, I don't care if it goes to court, it's my kids. I mean, it's whatever. I'm not alive. Everyone has their own opinion about this. But why you wouldn't want it to go to court is just because the time frame and the money. I talk about this all the time. Anytime there's court involved, it's expensive, it's time consuming for the family. So that's some of the driving factors of why someone would want to keep it out of court. Also guaranteeing that it's going to go the way you want it to. Because like, for instance, a spouse has the ability to throw out the other spouse's will. It's called a spousal election. You can throw out your other spouse's will. So we see this all the time in blended families. Maybe, you come together later in life, you get married, adult children, and you each put in place a will. Well, the surviving spouse is like, yeah, I don't like that because now I can just give it all to my kids. So they throw out the will. It's a spousal election. There's a lot of reasons why you can get rid of that will and just go with intestate succession. So you got to be aware of that. It's not ironclad like a trust is.
Okay. Well, that's a whole separate podcast, which we have several on in terms of what trusts are, why they're beneficial, and how to get started. So if you would like to learn more about trust, you're welcome to give us a call at 248-955-2842, 248-955-2842. And we're happy to help you set up a trust so that you can have more than a will. If you want to figure out what a trust means, you want to learn more about it first before you give us a call, no problem. Head on over to our channel, check it out. We got several videos. I'll link to them in the bottom as well. Thank you so much, Michael. Appreciate you. This is, more than a will, folks. You need more than a will.